The situation in Israel and Palestine raises some of the most complex and contested issues in international law. In the past few years, the International Court of Justice, the International Criminal Court, and a UN-backed independent commission of inquiry have all addressed various legal dimensions of the conflict, including the status of Israel's long-standing occupation of the Palestinian Territories, and its conduct of hostilities in the Gaza Strip. Just how have those bodies ruled? What have they chosen to condemn as violations of community norms, and what conduct has been silenced or omitted? And what does all of this mean in practice, both as a matter of international law, for third-party states, and for the people on the ground? This is the Just Security Podcast. I'm your host, Paresh Shah. Co-hosting with me is Just Security's executive editor, Matiange Sirleaf. Matiange is the Nathan Patz Professor of Law at the University of Maryland Francis King Carey School of Law. Joining the show to unpack how international law and institutions have addressed the situation in Palestine are Shahd Hammouri, Ardi Imseis, and Victor Kattan. Shahd is a lecturer in law at the University of Kent Law School. Ardi is an associate professor and the academic director of the International Law Program at Queen's University Law School. And Victor is an associate professor in public international law at the University of Nottingham School of Law. Just a note before we get started, because this is a longer episode, we'll include detailed timestamps in the show notes, where you can find portions of the discussion related to the two International Court of Justice cases, the UN-backed Independent Commission of Inquiry, and the International Criminal Court.
Hi, everyone. Thanks so much for joining the show. I want to begin our discussion on the most recent ruling from the International Court of Justice, which has been called on to adjudicate both structural and physical violence in Palestine. The ICJ, also called the World Court, is the principal court that can hear general disputes between states and give advisory opinions on international legal issues. It is an organ of the UN and focuses on determining state responsibility as opposed to individual criminal responsibility. The court issued an advisory opinion in the 2004 case on the legal consequences of the construction of a wall in the occupied Palestinian territory, which found that the construction of the separation wall inside the occupied Palestinian territories had to be halted because it was contrary to international law. Building on this precedent, the ICJ held a 6-day hearing this February in the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory case, where an unprecedented 52 states and 3 international organizations presented arguments about Israel's prolonged occupation of the Palestinian territories. It delivered its advisory opinion on July 19, 2024. We'll begin our discussion with hearing from Ardi. Ardi, I'd first like to start with the significance of this decision. Can you please provide us with a brief overview of the decision, including how it arrived at the ICJ and any key holdings?
Absolutely. First of all, thanks for hosting us and hosting this conversation, Matiange. It means a great deal at a pivotal time. The questions put before the court were done by the General Assembly on the 30th of December, 2022. In fact, there were 2 questions, legal questions, that were put before the court. The thrust of which, the nub of which, is to ask the court whether or not Israel's continued presence in the occupied Palestinian territory is lawful. By an overwhelming majority, the court heard the matter and ruled that Israel's continued presence in the occupied Palestinian territory is unlawful. And in the process of doing that, issued a number of statements of law, findings of fact, etc., that, in my respectful view, to answer your question, introduce, and this is not hyperbole, a paradigm shift in the international law concerning the occupied Palestinian territory, and that will have reverberations whose action is so potentially broad that they could have great reverberations both legally and politically going forward in ways that we couldn't have imagined some years ago. This follows in the line of cases against South Africa in Namibia. And the idea is that there's an anti-apartheid movement going on in Palestine, and that this opinion will serve a great benefit in respect of meeting the challenges that regime imposes. So some of the key findings made by the court. First of all, in respect of Israel, The court determined that the occupation by Israel of the occupied Palestinian territory since 1967, now going into its 57th year, forgive me, into its 58th year shortly, is unlawful. Now, many of your listeners or viewers might find this self-evident. I mean, so much law has been thrown at the Israel-Palestine conflict by the United Nations, including by the International Court of Justice as far back as 2004, as you'd mentioned earlier. So what's new in this finding? Well, it is true that the United Nations has documented chapter and verse a wide array of what we might call discrete or individual violations by Israel, the occupying power in the occupied Palestinian territory over many decades. For instance, settlements are unlawful, or deportation of the protected population, or torture of that population, or destruction of private property and homes, and so on. There is no shortage of United Nations effort and record over the years to demonstrate that Israel has engaged in discrete violations, a multiplicity of them, of international humanitarian law, that's the laws of war, or international human rights law. But what renders this finding different is that the court has been asked and has answered in the affirmative about the legality of the regime giving rise to the violation of each of these individual violations, the very presence of Israel in the occupied Palestinian territory. So the first thing is they've determined that Israel's presence is unlawful, and that everything Israel therefore does in the territory as an occupying power, which it continues to be, is tainted with illegality. Everything. The next finding is that as a result of this illegal action being the occupation, Israel has an obligation to make appropriate reparations. And you can imagine the breadth and scope of that. The court did not get into it, nor was it asked to get into it, and it may be in the future, who knows. But you can imagine the breadth and depth of reparations, which covers everything from restitution of property, real and personal, return of refugees, as well as compensation, as well as satisfaction, apologies, and things like that. It is a very broad category under international law, reparations, and this a very broad period of time over which they are owed, 57 years and counting. So those are the key findings against Israel. Of course, there are findings in respect to the settlements being unlawful, that every settlement must be removed, that every settler must be removed from the territory. So gone is the idea that somehow there will be, at least lawfully, settlers that remain in Palestine and so on. No, all of them are unlawful. They all must be brought to an end, that by which is meant removal from the territory. In addition, in respect of Israel, the court indicated that and found that Israel's regime is in fact a violation of Article 3 of the Convention on the Elimination of All Forms of Racial Discrimination. CERD is what we'll call it. I do believe that Victor may discuss this later on, so I won't wax lyrical. But the point here is that this means that the court determined in broad strokes that Israel is engaged in a regime or imposing a regime of racial segregation and apartheid. I'll stop there, but that you can imagine the importance of that for civil society actors and for other states and so on in terms of follow-up. In terms of third states, the court determined that all states, aside from Israel, all states have an obligation, first of all, not to recognize the legality of Israel's continued presence in the occupied territory. And very importantly, which we'll hear later on from Shahd, at least in part, to not render aid or assistance to Israel in the maintenance of this illegal presence in the occupied Palestinian territory. Again, the breadth of this is massive because you know Israel has had and has many bilateral relations with a wide array of states that touch on the Israelis' ability to continue their presence in the occupied territory. And this runs the gamut from military relations to economic relations to civil and cultural relations, political relations, and so on, diplomatic relations. And so what this means is finding that all states are under an obligation not to render aid or assistance in the maintenance of Israel's continued presence, illegal presence in the territory, is that their third states are going to have to reassess their bilateral relations with Israel in very substantive ways. And their foreign ministries are doing that now. I'm quite certain of it. They're at least looking at the impact of this opinion on certain relations that they share with Israel. And then there will be decisions that are taken. And of course, those decisions may or may not be perfect, but it will invite pressure from civil society to change the positions of these third states to make sure that they're more in line with their obligations under the opinion. And finally, there's findings in respect of the United Nations, and that the United Nations General Assembly in particular and the Security Council have to undertake all means to determine what modalities should be adopted by states and by the international community to bring Israel's presence in the territory to an end. And of course, which I failed to mention earlier, to ensure the right of the Palestinian peoples to exercise self-determination in the occupied Palestinian territory, which, again, the court affirmed is being violated with reckless abandon by the occupying power. There is some talk in the media about the fact that, and I'll end my initial comments here with your permission, there's some talk in the media, even by some legal commentators, sadly, suggestive that somehow this opinion is not binding. And while it is true that as an advisory opinion, and looking at the jurisdiction of the court, technically it's not binding on the parties to the conflict, because the parties to the conflict haven't been brought before the court in a contentious dispute, which would, in the normal course under the ICJ statute, be binding. There's no question that as the principal judicial organ of the United Nations, mandated uniquely so on planet Earth, with providing authoritative interpretations of public international law, and with the fact that the court has done so in this case in respect of international legal principles that across the board amount to customary international law, which is already binding on all states, many principles of which are what we call peremptory norms, derogation from which is not permitted, and invite obligations or entail obligations of erga omnes effect, that is pressable against the whole of the international community. All of that is binding as a matter of public international law. There's very little in the opinion, very, very little, if anything, that isn't, as a matter of general international law, already binding on all states, including Israel, third states, and the United Nations. And so that's something that needs to be made. In short, I wrap up. This is a sea change, as I mentioned earlier, on the international law concerning the Israel-Palestine conflict. It invites a great deal of follow-up, which will happen. And only time will tell what that means for the apartheid regime in the occupied Palestinian territory.
Thank you so much for that comprehensive overview of the decision, which seems very wide-ranging and incredibly significant. And so I wanted to bring some other voices in now. Victor, if it's okay, I'll come to you. I just wanted to see if you could weigh in on whether there were any areas that you wish the court expounded on more, or whether there were any gaps in the decision.
Thank you, Matienge. It's a pleasure to be here and to see Ardi and Shahd, old friends. So Ardi referred to Article 3 of the International Convention on the Elimination of All Forms of Racial Discrimination, which the court determined had been breached, and that provision refers to racial segregation and apartheid and eliminating all these types of practices. But the court was a little bit vague on the issue of apartheid, so it didn't go into any real depth as such. It spoke a little bit about segregation, but it didn't provide a definition of apartheid under customary international law, as some of the states argued before the court, or kind of tried to persuade the court to do that. However, a number of judges in their separate opinions and declarations did look at the apartheid issue in quite some depth, including the South African judge Tladi, the president of the court, Salem, even Nolte provided an interpretation of apartheid in international law. Plus, I think the Japanese judge and the Brazilian judge as well. So about 6 of the 15 judges went into quite a lot of depth, which was quite interesting. And their approach actually overlapped. So they argued that apartheid has certain the way it's defined in the 1973 Apartheid Convention and the Rome Statutes, while they're different, there is an overlap. There's reference to institutionalized discrimination, domination, and this kind of systematic discrimination. And in fact, if you look at the opinion, it uses this particular phrase, systematic or systemic discrimination, which is really intriguing because in the section on discrimination in the opinion, they refer to the main human rights treaties on discrimination, the UN Charter, the Bill of Rights, CERD, etc. But none of these conventions actually use the word systemic. They just simply define discrimination. So the way I read it is systemic is maybe a way for those judges who wanted there to be a reference to apartheid but didn't get it. They threw in this intriguing phrase, systemic discrimination. And when I was reading the opinion, I read it again this morning, and because I do a lot of work on apartheid, when I was reading other bits of the opinion, for me it just read like they described an apartheid regime. So denial of self-determination. I mean, that's domination, right? The discrimination, obviously, the segregation. But even things like annexation or channeling legislation or trying to integrate or separate or fragment territory, all these things are hallmarks of what happened in Southern Africa during the apartheid regime. So it's almost like the opinions kind of described the regime, but without providing a word that they could use to say what it is. But I think the issue of apartheid was on the back of mind of several of the judges, and that comes out in these separate opinions. And of course, an apartheid finding, as Ardi alluded to, would have consequences under the treaties that were referenced, the 1973 Apartheid Convention and the Rome Statutes, which we'll be discussing, I think, a little bit later.
Thanks for that. I want to turn to now how the court's decision has been received by other states.
Look, it appears that it's varied how various states are referring to it. Some are ignoring it, very few. Many have indicated that they are reviewing it. That I would say that most states that I've seen reports on are indicating that they're reviewing it, with sometimes an affirmation that those states in their review have a great deal of respect for the, quote, independence of the ICJ. So it's just an affirmation of their own claimed fidelity to international law. It's still early days, however, and so I don't think that we've seen any great action taken on the back or on the sales of this opinion. There has been in Canada, for instance, a recent decision just a few days ago that was taken by the government, but clearly on the basis of earlier pressure being brought to bear on it, but which, when you examine it, would fit quite nicely and flow quite perfectly, in fact, from the third state obligations that I'd mentioned earlier that were pronounced upon by the court. And that is the Canadian government has just taken a decision to withdraw the charitable status of the Jewish National Fund in Canada. And it's that type of action writ large that will end up having an impact on bilateral relations with the occupying power, the illegal occupying power, and so on. So that's my read of what the response has been from states early going. We'll see. The most important thing in terms of response, we'll see what that looks like when the General Assembly meets in the coming session. The first major follow-up, if you like, action in respect of this advisory opinion is going to be a resolution of the General Assembly receiving the opinion and determining a couple of things, ideally setting out some of the modalities that the international community has to undertake in order to discharge their own obligations to end Israel's illegal presence in the territory, but most importantly, setting a deadline, an actual date that Israel has to end the occupation by. We saw in the Chagos case, 2019, the ICJ has an advisory opinion. It is asked whether or not the 1965 decolonization by the United Kingdom of the Chagos Islands was lawful. The court determines that it wasn't, and that the United Kingdom's continued presence in the Chagos Islands or continued administration of the territory is unlawful and must, quote, end as rapidly as possible. The court in this case used the same terminology, as rapidly as possible. And the question is, well, what does that mean, as rapidly as possible, in concrete terms? Well, in the Chagos matter, when the General Assembly received the opinion, they affixed a 6-month timestamp on it. That is to say, the continued administration by the United Kingdom of the Chagos Island had to end within 6 months. And so I'm not entirely sure whether or not we'll see that sort of timeline here, but there will be a timeline attempted to be placed in the General Assembly resolution. A lot of work will be brought into that, and then you'll get a better sense of what the international community response is, if you like, in real terms.
If I may add a little bit to that. So if you look at the language used by the court is, as Ardi noted kindly, the court is telling us that Israel is committing systemic violations of international law that are quite embedded into its war economy. And the only way to understand the duty of non-recognition and the duty of cooperation in this case would be to actually comprehend how the Israeli war economy works. Of course, that starts with transparency on the part of states as to their contribution to that war economy, but it also asks states to partake in their own influence to affect that war economy and find ways in which they can also influence Israel in one form or the other to stop the illegalities committed. Because even when you look at the prolonged nature of this violation, we have a clear understanding that Israel does not recognize its own obligations, and that needs to translate into how states understand their obligations. And by that I mean, we're now looking towards the first step being an arms and energy embargo taken forward by the UN General Assembly, so as to start the economic pressure on Israel to stop its illegality. Then, of course, here we're inspired by the model of South Africa. But then, indeed, we need the support of states to enact these obligations and for them to be taken seriously. So we expect that this is going to be a long way, and we expect that states of the global south, like Latin American states, will be earlier in adhering to their international legal obligations, and we expect that more economically advanced states will find argumentative techniques to limit or deny these state obligations. But it's quite clear that the way forward is to make this occupation economically unviable for Israel.
Shahd, thanks so much for that. I was actually going to turn to thinking more about, in practical terms, how implementing this decision might impact the realities on the ground in Palestine. And so, what other obligations of third parties do you all see as material? Perhaps we can bring Victor in on this.
Thanks, Matiangi. I think I just wanted to jump in on I agree with what's been said by Ardi and Shahd. But I noticed that people have referred to South Africa, and then the 1971 Namibia opinion came up several times in the arguments. But I think it's worth recalling how that opinion was basically at the time totally ignored by the United Kingdom, for example, and the United States. So although there are obviously obligations, the opinion is an authoritative statement of the law. There are moral arguments, other arguments one can think of to impose boycotts and sanctions and embargoes on Israel for what it's doing in Gaza. There's always this disjuncture between the enforcement of law and what states should behave and how they actually do behave. And I think it might be, although we're lawyers, so we think law obviously is important. International law is something states should all respect. I think we shouldn't also lose sight of other arguments that we can make in addition to legal arguments, especially when it gets to the political organs of the United Nations. And it might be a case of getting a small group of states, maybe not so powerful states, maybe states from the global south, as others have mentioned, to get the ball rolling. But I think this opinion is helpful because it helps us legitimize the discourse and the argument for sanctions, which were once a taboo. And Ardi and I are old enough to remember what the situation was like 10, 15, or 5 years ago even, when you couldn't even make these arguments. So I think it's helpful in that regard. But at the end of the day, there's no way of enforcing the court's opinion, other than perhaps through domestic cases, secondary obligations and things like that. But that will take a long time to do.
Ardi, did you want to react to that?
Yeah, it's not so much a reaction. It's just an affirmation of the view. Victor takes a very sober and I think accurate analysis, which I share. One of the things that I neglected to mention earlier that I would like to raise here, which touches on the international community's response, obligations and or likely response, or unlikely as it happens, has to do with what I call the negotiations condition. For decades, certainly since Oslo, the Palestinians have been told, and uniformly so by the international community, by friends and foe alike, by the UN Secretary General and General Assembly and all of them, that the only way to end the occupation is through bilateral or some form of negotiation with the occupying power. Now, negotiations on their face make sense in most situations of international conflict, because they signal the Pacific disputes, just settlement of disputes, and it's better to solve disputes specifically than it is to do so by war. So on their face, they make sense. The problem here is that under international law of state responsibility, and even under domestic law, I mean, the most basic principles of law, where somebody commits an internationally wrongful act or a wrongful act, they don't have a right legally to insist that the only way that that act ends should be through negotiation. So the same is true under international law. And the internationally wrongful act here is the occupation itself. And so there are only three obligations set out by the International Court of Justice and under the law of state responsibility on Israel in relation to its continued illegal presence in the territory. First, that is the duty of cessation. That is to end their occupation unconditionally of the territory as rapidly as possible. Second, to make appropriate assurances of non-repetition, which I don't think the court mentioned this time around, but it is part of the law of state responsibility. And third, to make appropriate reparation, which the court did, as I'd said earlier, affirm that Israel has obligation to do. But you note that none of that mentions ending the occupation through negotiation. And the court did not make any reference to the need for the parties to negotiate an end to the occupation. Now, all of this, of course, makes perfect sense. So why does that matter? Well, it's going to undercut what I call the negotiations condition, which third states have placed, and I think in large part in bad faith, on the Palestinians over many, many years, because they know full well that there's nothing to negotiate. This is a bad faith occupying power that is imposing a regime of racial segregation and or apartheid on the territory. It is annexing that territory. It is claiming that territory for itself and only itself in terms of their sovereign right purportedly to the territory, all of which has been determined to be unlawful. And so it will be interesting to see how third states respond to this. There's no longer the requirement to negotiate the end of the occupation. No discussions over modalities on how to end it. Yes. The practical aspects of ending it in total. Yes. And by the deadline to be set by the General Assembly in the upcoming resolution this session. Yes. But not to negotiate its terms. And you see that. I was doing an interview the other day on Al Jazeera International, and an otherwise very intelligent Israeli international relations scholar had said something to the effect of, it was almost inertia. He said, well, everybody knows that in the end of the day, some settlements will remain and the parties will negotiate. That's an old talking point. That's not relevant anymore. The whole thing needs to be brought to an end unconditionally and as rapidly as possible.
I wanted to have you all reflect on just the role of the UN Security Council here, for obvious reasons. This came before the court through the General Assembly, and so the UN Security Council is the only one that can make, under Chapter 7, binding decisions on the international community. And so I wanted to get some thoughts on where you see the UN Security Council acting, or not acting rather, in this space in terms of enforcing the ICJ's decision.
I mean, as long as there's no change in US foreign policy, there's I don't see any substantial change at the Security Council. And we can see this was the issue of Palestinian statehood that remains deadlocked. So Palestine, the General Assembly's basically done everything it can to give Palestine additional powers beyond that of any other non-member observer state. But at the end of the day, to become a full member, they need acquiescence of the UN Security Council, which isn't forthcoming. But I don't know. You'll know better than me, based in the US, if the elections will make any difference. But based on past experience, it's unlikely. We're unlikely to see. Well, you never know. In South Africa, it was the same, and then in 1977 they imposed an arms embargo. So you don't know. Things can change, but it's probably unlikely.
When we understand this, we need to get the military-industrial complex side of it, and the reality remains that the U.S. has very clear interest in the proliferation of war in the region, and as well as corporate actors in the U.S. who play a very important legal role in shaping U.S. policy, which is sadly why we can't see it. And to address the point in relation to Israel's insistence not to see reality. Here we see a little bit of Judge Sibantonde, and I'm very sorry for the mispronunciation, Sibantonde's decision, where she clearly insists on a narrative of the Israeli claim to land. And the fact that this is entertained in an international court of justice is beyond me. And especially that it's quite surprising to find a judge who is using no footnotes and is directly citing wrong histories based on their own personal beliefs. So you can see that system of belief is the one that is in the majority of the Israeli society. And that is a prominent system of belief that has facilitated the settler colonial project. And the expected thing is that we're only going to see this become even more entrenched, because Israel has premised itself on some very specific comprehension of Judaism while it's a secular state. So we will see it fall into a huge set of contradictions in how it tries to explain itself and legitimize its project internally as we go forward, especially that now it lost its European legitimization card, so to speak, with the fact that actually even in a language that is set, the parameters of which are set by what can only be called colonial residues, the Palestinians now can actually conceptualize and claim their rights, not just as moral rights, but as legal rights. And as Ardi noted, the premises of the conversation no longer can include the negotiation of the illegal. And what the International Court of Justice is telling Israel is, now you're a rogue state. You're outside of the international legal system. And this is the message that we need to stress. And that's that narrative being sold by Israel, where it doesn't recognize even that it's committing internationally wrongful acts up until this moment.
So thanks so much for that, Shahd. That was really illuminating. And thinking not only about the challenges at the UN Security Council, I think it's important that we also reflect on the challenges with respect to Israel in terms of implementing the court's decision. As you all may know, the Israeli Knesset really recently voted rejecting the establishment of a Palestinian state. And so thinking about the enforcement challenges moving forward, given this decision, it would be helpful if you, Ardi, can start reflecting on what you think the significance of that is.
I actually anticipate that, although it's not legally required by states to recognize the state of Palestine, that recognition of statehood is a political prerogative. It isn't a requirement under international law. I suspect that this opinion is going to provide wind in the sails of the press to increase the number of bilateral recognitions that Palestine has in the world today. So now there's about 149 states, including the Holy See, a non-member observer state of the United Nations, 149 that recognize Palestine in a field of just about 200 states in the world, representing the vast majority of people in the world. That will only increase, I think, because some states will think, all right, well, what can we do to help push forward the two-state solution? And recognition is an obvious one. It's a holding operation to make sure that the Israelis have affirmed for them that although they may share bilateral relations with the recognizing states themselves, Israel is not the occupied Palestinian territory. It isn't occupied Palestine, and therefore there's no reason why they shouldn't recognize the occupied state of Palestine as a state as such. Membership is another matter, as Victor just mentioned, and it would be blocked by the United States until the very end. There's little question about that. The historical record is clear on that. So that might be something that we end up seeing flowing from this opinion, and not as a legal requirement, as I said earlier, but simply as a political fact.
I think the Knesset vote is interesting, saying that they won't recognize a Palestinian state, that they're opposed to it. But I think it's worth remembering that that's been the Likud party platform since 1977. So the Knesset coming out and saying that is perhaps nothing new. But I suppose it's formalized it. It's going beyond the Likud to all members of the legislature. It occurred to me when we were talking, when Ardi was speaking, that if there are no negotiations or no likelihood of negotiations, the Israelis are opposed to, or never going to recognize a Palestinian state. And yet the EU is funding and continues to fund in the tune of billions the existence of the Palestinian Authority. I know this is a double-edged sword here. The question might be asked, why are they continuing to fund this two-state solution, or this negotiation process that never actually happens? And one wonders whether that might provide leverage, because critics have argued that this funding is actually propping up the occupation. It's what's allowing Israel to prolong it, because it's the costs of it, the cost of employing hundreds of thousands of civil servants, of assisting with construction, or the whole economic and social cultural fabric of a nation in areas A and B. If it's being funded by donors, and that money is no longer coming in, and the Israelis will have to take the full burden and responsibility of having to do that, it might make people in the Israeli security establishment have second thoughts about current policy. So it could be a way in which and using the advisory opinion could be a way in which, and the resolution that comes out of the GA in the fall, it could be a lever to perhaps encourage movement in this area.
Thanks for those reflections. So I just wanted us to talk about the right of return, because the court's decision mentions the right of return, and in terms of impacting realities on the ground, but also just what the significance of that decision is, right? Because that's something that has been a point of contestation for some time. And so can we have some reflections on that? I'm not sure who wants to jump in first here. Shahd, thanks.
Just a quick note. So just to be clear, the right of return exists for anyone, the descendants of Palestinians who've been displaced ever since 1948. So those who were also displaced with the making of the Israeli state, and that right is not disputable according to UN official documents. It has been reiterated on and on again. And actually, when you look at the negotiations for the establishment of the State of Israel, one of the conditions that was indirectly taken for the establishment of the state was the recognition of the right of return for all the Arab population displaced. And you can note that a lot of the European representatives at that moment said that it would be unimaginable that we would do that to the Arab population. And yet Israel quite conveniently forgot that. So the right of return that has been reiterated in the ICJ decision now is the right of return of people who have been displaced since 1967, which is the occupation of the West Bank, East Jerusalem, and Gaza, of course, along with the Golan Heights and Sinai at the time. So in that respect, what we are looking for is, again, it's already clearly legally established. It is just the reassurance of having it being said as well along the line of reparations. But I'm sure Ardi will have a lot more to say about that.
No, as it happens, Shahd, you've covered it quite nicely. The court, in fact, doesn't deal with the right of Palestinian refugees from the 1947, 48, 49 conflict. It does deal with displaced persons and Palestinian refugees from the 1967 conflict, impliedly through its reference to reparations and the requirement of Israel to make appropriate reparations in terms of restitution of property and return and so on, following its illegal occupation. So there's that. Although, and we spoke earlier about gaps in the opinion, although they were invited. The court was invited to deal with issues, what we say behind the green line. If you look at the State of Palestine's written submission, you'll see that there's a good number of submissions that are made about racial discrimination, about the refugees, that is the 1948 refugees, and so on, all of which relate to Palestinian rights behind the green line. And the court took a decision early on when it was assessing the territorial material scope, both of those, even the temporal scope of the questions put before it. The court took a clear decision, as we had anticipated that it would, notwithstanding the fact that we made those arguments, took a decision to focus on the 67 territories.
Yeah, I was quite intrigued to see. I know its focus was on post-1967, but I was almost dumbfounded when I saw a paragraph referring to the Defence Emergency Regulations of 1948. So these are British regulations. There's a big debate whether they're still in force, but the Israelis use them to demolish Palestinian homes. So they're very, broadly drafted. So yeah, it's intriguing to see that although they're focusing on post-67, they're actually referring to laws from the mandate from the colonial period. So I thought they were a bit light on the treatment of the mandate and also of the holy places in Jerusalem, in contrast to the 2004 advisory opinion. But but I was intrigued to see that. So maybe there's room to bring in future arguments before the court going further back in time.
But lest if I might carry on the back of Victor's comment, lest the listeners take a cynical view by virtue of these slight criticisms that we offer of what the court did. I would invite you all to be mindful of the fact that in any case before the International Court of Justice, you have a panel of 15 judges, sometimes 17 if you have ad hoc judges. In this case, it was 15 because it's an advisory opinion. No need for the ad hocs. You're going to have the challenge put before the president of the court and those who are drafting the opinion to try and bring as large a consensus as possible. Because the court's going to want to speak with as much of a single voice as possible on all the main issues. These are the reasons why there are some gaps in the opinion. For instance, Victor had mentioned earlier the I don't know what we'll call it, the lack of clarity of the majority on the apartheid question, even though it did mention that there's a violation of Article 3 of CERD. That lack of clarity is likely the result of differences of opinion and the need to get as many judges in the majority to sign off on the thing. And that would explain some of the gaps. None of that is any reason at all to understand this opinion as anything other than a sea change, as I said earlier, on the international law concerning the question of Palestine.
Thanks for those concluding remarks. The ICJ has been really active of late. And so we're going to turn to discussing another ICJ case. And Pras, can you take it away here?
Thanks so much, Matiange. Yeah, as you mentioned, there is another case before the ICJ. This one is a contested case between South Africa and Israel. South Africa filed the case in December 2023, and it's concerning the 1948 Genocide Convention. South Africa submits that Israel has engaged in, is engaging in, and risks further engaging in genocidal acts against the Palestinian people in Gaza. And it requested a provisional order as a matter of extreme urgency to protect Palestinians from further severe and irreparable harm. The court granted 6 of the 9 provisional measures that South Africa sought in January of this year. And South Africa has repeatedly returned to the ICJ to seek additional emergency orders. In May, the ICJ ordered the latest round of additional provisional measures, and it won't deliver a final judgment on the merits in this case for several years. So again, the procedural posture here is still quite early, but still an important case nonetheless. Matiange, I'd like to start with you. What do you see as the significance of the case and the provisional orders that the court has issued thus far?
Thank you so much for asking me this. I mean, I think that the significance of this case is quite profound. So the first thing to note is the court didn't dismiss the case as Israel had requested. Instead, it found the existence of a dispute and that at least some of the acts and omissions alleged by South Africa have been committed by Israel, and that those appear to be capable of falling within the provisions of the Genocide Convention. And as you noted, the court has gotten sort of increasingly more expansive in its provisional measures. And one of the things that we can say at this early date is that the fact that the court allowed 6 of the 9 measures sought by South Africa in its initial application speaks to the legal plausibility of the case, right? So the provisional measures are something that are brought before the International Court of Justice in the event of an emergency, right? And the court found a number of things that are significant, right? That at least some of the rights claimed are plausible. This is the case with respect to the right of Palestinians in Gaza to be protected from acts of genocide and related prohibited acts. And the court asked Israel to take a number of measures within its power to prevent and punish direct and public incitement to the commission of genocide, and that Israel should take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance, as well as preserving evidence regarding allegations of genocide. And as you noted in your introductory remarks, South Africa has had to return repeatedly to the International Court of Justice to request additional provisional measures because of the noncompliance with the provisional measures to date. Following the initial provisional order from the ICJ, Israel reportedly killed almost 900 Palestinians. Israel has announced plans and, in fact, has launched a ground invasion in Rafah, which, as we know, currently houses primarily in makeshift tents more than half of Gaza's population. And these evacuation orders for people to leave their homes and continued evacuation orders for people to leave their homes has undermined a number of the provisional measures sought by the court in terms of protecting individuals. And in light of this, on February 12th, South Africa filed for an urgent request for additional measures. And the court initially just sort of reiterated its prior provisional order in January. And subsequently, South Africa returned to the court requesting an additional provisional measures in March 6th, this time concerning the widespread starvation in Gaza. And the court found that famine is setting in, and ordered Israel to continue to follow prior provisional orders and to take all necessary and effective measures to ensure, without delay, the unhindered provision at scale needed for basic services and humanitarian assistance. And importantly, the court says that its military should not continue to commit acts that would constitute a violation of any rights of Palestinians in Gaza as a protected group underneath the Genocide Convention. And as you noted, most recently, the court has said that Israel should, on May 24th, halt its military offensive and any other actions in the Rafah Governorate, which may inflict on the Palestinian group in Gaza conditions of life that could bring about its physical destruction in whole or in part. And so while the initial order before in January didn't call for explicit ceasefire and halt of its military offensive, we can see by May that the ICJ is making that provisional order. And so I think that presents a synopsis of how the provisional measures have grown in terms of their coverage. And I'll stop there to see if anybody else wants to add.
My only addition to that is the focus on third state responsibility that arises from engaging the Genocide Convention. And this has been a point that a lot of states have tried to overlook. The fact that the Genocide Convention is now engaged means that states have the duty to prevent genocide and also not to be complicit in genocide. And these duties are grave and they're big. And the duty to prevent genocide, again, is assessed in relation to the state's capacity to influence the perpetrating or possibly perpetrator state. In this case, states have been under the obligation ever since the first provisional measures to partake in all positive action possible in order to protect the Palestinian people against irreparable damage. So considerably, this was very easily and directly an argument for an arms embargo. Some states have abided by that. For example, Colombia, Mexico have taken positive decisions to actually enact their duty to prevent genocide. But sadly, we saw less of that in the US and Europe. States like Spain and Belgium have taken some steps as well towards that. But there's been extensive legal argumentation that was then, of course, taken forward by UN experts who twice called for an arms embargo. And then, of course, that was enacted in a Human Rights Council decision in April that referenced the ICJ's decision and asked for an arms embargo, among other things. Here, even the Human Rights Council talked about a three-way embargo, which also included not buying or transiting the weapons.
Yeah, I suppose going beyond the provisional measures, I think it's going to be quite challenging going forward to prove the genocide claim, given the previous jurisprudence of the ICJ. So even though it's clear that Israel's committed systematic violations of international humanitarian law, human rights law, it doesn't necessarily translate as it's committing genocide in the sense of specific intent, or that's the only reasonable inference is that it wants to destroy Palestinians as a group rather than displace them or harm them in different ways. So that's what the Israeli argument will be, and I think there's an attempt, one can sense from South Africa, that they're trying to broaden the meaning and interpretation of genocide through the crime of apartheid, and you see that because in May South Africa finally acceded to the 1973 apartheid convention, which they hadn't done at all, which you might find rather bizarre. But one explanation for doing that would be because the way in which apartheid is defined overlaps. Certain words are identical to what appear in genocide, but the apartheid convention has the advantage in that you're describing the overall regime, the structural violence, the context in which it's occurring. And so it might be that, and you can see in their original application of South Africa that they're trying to argue that this is occurring in a broader context. So there might be an element or an attempt to if you like, broaden what genocide is to make the argument a bit stronger. And I should also mention that there have been several states. Ardi's mentioned Palestine has now intervened. I think several Latin American states have also intervened in support of the application. I think there are some other countries who will be making applications shortly. So it's obviously it's an ongoing live case that will likely last several years.
I also think that the Genocide Convention on its face, in terms of provisions that relate to deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, might permit, and does permit rather, a structural account, right? A more systemic way in thinking about how genocide is enacted, and that is a perspective that's not based on sort of a total annihilation unnecessarily, but one in which through conditions, which we can think of through recently bombing of water systems, but a number of other spaces in which there is the deliberate inflicting on Palestinians physical destruction, and I don't want us to lose sight of the fact that there is within the convention itself, I think reasons for thinking about how this is systemic and structural. And in the Myanmar case that related to genocide, we saw a number of takes by countries like the United Kingdom, Canada, Denmark, France, and the like, which talked about broadening the definition and using a lower threshold for determining genocide such that it's not as difficult to show the specific intent. In particular, they said in the Myanmar case that declarations of intent to commit genocide are rare. And so that the court shouldn't solely focus on sort of explicit statements or numbers killed, but reasonable inferences that can be drawn from a pattern of conduct and factual evidence. And in their intervention in the Myanmar case, they talked about the fact that genocidal actions can include forced displacements from homes, deprivation of medical services, and the imposition of subsistence diets, if systematic. All of those things are taking place in Palestine today. And so I think that there is enough to think about structurally how genocide is being committed.
If I may just step in very fast, also, we have to also take into consideration that the current decision of the court in the advisory opinion, as well as the opinions by the judges, can also guide us towards what could possibly be future arguments. In the sense, one important note is that we have two judges who noted that, for example, Israel's security claim is invalid, and this is also in the decision of the court in saying that you cannot claim Israel's security over international legal obligations, and international legal obligations override that, which is very important. And in this case, why is it that we look at Israel's security considerations and not Palestinians? And this also throws to the wall a big part of Israel's argument, in the sense that also it is partaking this war in Gaza for a legitimate military target, because the idea here is that annihilating Hamas doesn't function as a legitimate military target, and actually entertaining that is quite a violent act to partake, because if you annihilate one form, Hamas, for example, today, that doesn't mean that Palestinians are not gonna partake in acts of armed resistance in any other way. And here we have the position of Judge Hilary Charlesworth also, who did reference the right of resistance. So what I'm trying to say is it would be very unfortunate if the International Court of Justice decides to marry itself to a very conservative European lens in its interpretation of international law. A very clear context is the one that we're speaking of here, which is settler colonization. If you decide to ignore the history of states of the global south and deny the histories of colonization, which clearly give us one lesson learned: settler colonization and genocide go hand in hand. And which is why it's important to understand that broader picture. And what Victor was alluding to, using the language in the Apartheid Convention, is the step for and the way forward. But if the court decides to marry itself to the more conservative understanding, then sadly, it has decided to find a very narrow interpretation that says that international law only builds itself on a very limited understanding of human history, and really negates the histories of others. And this really should be, I think, in the next few years, as we look towards that, a focus of academic scholarship and a focus of activism, because if international law is to live, then it needs to escape the absurdity of not comprehending the innate relationship between the two things, settler colonization and intent on genocide.
You mentioned self-defense, and it made me think about how the International Court of Justice, in its initial provisional order decision, did not address Israel's self-defense argument. And that is because the reason why an actor uses force and its validity is legally irrelevant in terms of determining what one can do after resorting to force. international law has two bodies of law that govern the justice of war and different ones that govern just and fair conduct once you're in war. Just and fair conduct once you're in war is known as international humanitarian law, and that law regulates the conduct of parties engaged in armed conflict, irrespective of the legality of the decision to use force. So the claimed justness of the cause of war then doesn't give you carte blanche to use any means and methods of force in conflict. And so with respect to self-defense, which is an argument about the justness of the use of force, doesn't mean that there are unlimited means and methods of force. So instead, there's a proportionality requirement such that even if you use force and that use of force is deemed justified and necessary, the type and amount of force used still has to be proportional. So arguments around the self-defense don't really have any legal basis, because you can't use the reason why you used force as a defense to charges of war crimes, or as a defense to charges of crimes against humanity, or as a defense to charges of genocide. All right, so you can't turn back to the purported legality of your initial decision to use force when you are faced with allegations of war crimes, crimes against humanity, and genocide. I think it's important to reflect on that, because I think that means that even if you accept the self-defense argument, which many do not accept the self-defense argument, right? So some argue that, what's happening is actually a retaliatory attack after an attack has been concluded, right? So this is more akin to a reprisal as opposed to, and collective punishment, as opposed to a legitimate use of self-defense. Others have talked about how thinking about self-defense is used outside of a territory. It refers to the use of force outside of a territory, rather, and it's not applicable to thinking about an occupied territory, using self-defense in an occupied territory. And I think that the legal debates around those things are really profound and interesting to think about, because I think they challenge just the use of self-defense, period. But I think more critically, even if you accept the argument that self-defense is warranted, then there are still limits on what you can do in terms of the use of force. And I think it's important to just surface that.
Thanks to all of you for those reflections and overview. Mationge, I want to turn to you on what we can expect next in the case, and particularly the impact on the ground.
So thank you so much for that, Paras. And I think it's important to sort of situate the genocide case amongst the cases that have come forward in this space. And I think that the court's decision, we will not get anything from the court for some years, but it's important to see how states have sort of lined up to intervene in the case publicly, and those who have sort of publicly expressed support for the case. As those of you might know, the United States sought to discredit South Africa's case. A number of individuals within the U.S. Congress also sought to discredit the case. But I think that as the months have gone on, and thinking about the court's provisional orders, South Africa's case has only become stronger in some sense, and we'll wait to see what the final decision is from the court. But I think that whereas the claims of both the United States and Israel that the case is baseless and the like really seem quite unfounded. And so we'll see what the court does. But I think more importantly than what the court does is thinking about changing the realities on the ground, right? And so I think that in the focus on the legal classifications of particular international crimes, I don't want us to get lost in sort of a technical discourse about what standards have or have not been met, because in some ways the hyper focus on labeling can conceal the incredibly unjust status quo that is happening on the ground in Palestine, and divert our attention from its oppressive character and potentially limit organizing for alternative ways of being.
I also think the language is also pretty distinct. I mean, especially in the first months of the conflict, incitement to genocide. I mean, they were very clearly not just going after Hamas, but after the whole Palestinian population. That also comes out in the UN Independent Fact-Finding Mission reports from May. So there's hundreds of examples of statements which could support the claim that you just made, Matiangi.
Thank you for that. And Victor had mentioned the United Nations Independent International Commission of Inquiry on the occupied Palestinian territory, including East Jerusalem. So in June, the Commission of Inquiry presented its report to the United Nations Human Rights Council. The Commission's investigations covered the period from October 7th, 2023 to December 31st, 2023. Its investigations are ongoing. Shahd, you've written that there are several ways that the Commission fell short of meeting its obligations of truth-telling. And so perhaps we'll begin with you to give us a brief overview of the report and what the Commission found.
Thank you for that. So to start with, it's really important to note that the Commission of Inquiry is tasked with looking at root causes of the ongoing subjugation of the Palestinian people and the ongoing conflict. So it is important to note that this has been the idea behind the commission has been to provide a holistic reading of the situation and to enable us to connect the dots. And in this report, I'll just start by shedding light on some of the main issues that came to light with it or that were affirmed by it, and then perhaps I'll provide some short commentary. So there were two reports, each 100 plus pages, and the first one was in relation to October 7th. So the new things that the Commission has affirmed was, first of all, it cast a doubt on some of the narratives sold by Israel, and it said that the IDF itself failed on every front. It ascertained that the IDF had used the Hannibal Directive during its operations, and the Hannibal Directive is a military strategy where soldiers are ordered to kill anyone who might be taken as hostage. So they would prefer that civilians or combatants be killed rather than be taken hostage. And they also affirmed the usage of al-Dahiya doctrine, which is Israeli military strategy that seeks to inflict as much civilian harm as possible in order to affect the positioning or decision making of the other belligerent. So here we're looking at direct affirmations of these two, which were almost taboo to mention in October and November, and it does discuss some of the misinformation that happened in the media. Aside from that, it engages with lengthy narratives of what the victims of October 7th had gone through, concludes that war crimes were caused as well as intentional targeting of civilians. It's very notable that the Commission gave very vague remarks on sexual violence. Despite the fact that the existence of sexual violence on October 7th is a highly disputed matter. You can also see it in the courts, in the Commission of Inquiry's reporting. What is quite disturbing is that the Commission doesn't really articulate clearly how one misinformation as well as mass media utilization of the narrative sold by the Israeli government immediately after October 7th worked as atrocity propaganda, which should have been dealt with much more nuance and comprehension to the danger, and how the narrative then sold by the Israeli army was used to propagate and set the conditions possible for what happened later in Gaza. So in short, this is what you could find in that. It provides also ample evidence in relation to exactly what had happened. Of course, it is notable that the Commission of Inquiry engages with some sources and not others. For example, you can see a lot of appreciation of international media, but much less appreciation of other sources of media, especially Arab sources, or as well as Palestinian NGOs. As per the second report on Gaza, it's notable that the Commission of Inquiry has a critical position on Israel's self-defense claim. Has noted wide violations of international humanitarian law, starvation as a method of warfare, evacuation orders as not being efficient, and sexual violence against Palestinians. What is a notable absence here is that there wasn't discussion of detainees or the extent of the use of medical warfare. When questioned, the Commission said that it would like to discuss these in later reports. However, the larger problem actually is that the Commission had entertained a lot of the Israeli narratives with relation to what happens in Gaza. For example, it gave some merit to the human shielding argument put forth by Israel in relation to the urban warfare nature of the ongoing war in Gaza, and as has been reiterated on and on again by leading scholars in the field, such as Nicola Perugini and Neve Gordon. The use of the human shielding argument in a settler colonial context has historically been used to normalize the targeting of civilians, especially in this context. So to a point, the Commission of Inquiry engaged itself in a logic that was used to then justify genocide, and in general, when reading the reports by the Commission of Inquiry, one finds a very forced balancing activity that the Commission of Inquiry partook in, as well as a very fragmented narrative of it pointing to different violations, but not really doing what it's meant to do, which is to connect the dots for the reader. While it feels comfortable making judgments about war crimes and crimes against humanity, it omits the crime of genocide from its analysis. And this has been a very important point of critique for the Palestinian civil society, who felt that this was very important. And who felt that actually an analysis of genocide that does link the root causes of this ongoing war conflict to the ongoing events is very important, and actually would help the International Court of Justice in its decisions in the future. Sadly, we didn't see that from the Commission of Inquiry. Further, again, it's as if the Commission hadn't reached the conceptualization of what are the root causes that it's speaking of. It speaks again very as if it was an actor that was very disconnected from the context. It is very easy to see how it humanized Israelis much more than it did with the Palestinians, in the sense of the Israelis were always entertained in their own personal stories. Even reading it, you'd be much more empathetic to the stories. It was more inclined to treat Palestinian casualties in terms of numbers, and also to not to engage with kind of Palestinian conceptualization of their own reality. And at some points, actually underestimating them. Of course, it is notable that the Commission of Inquiry has been under heavy criticism by the State of Israel as well as other funding states. But the question here is, what did it have to lose if it were to actually partake in an approach that would have perhaps been more genuine or more representative of the perception of the population that has lived under subjugation for over 75 years? And you can notice that the in the accounts entertained by the Commission as well as its way of thinking. So perhaps my critique goes beyond the Commission of Inquiry towards the fact that it is very sad that in international legal discussion or within the belief system of the United Nations, it's still normal to partake in such a rhetoric that is very far away. And here, my point of reference, if you were someone who is currently in Gaza who read this report, you would be disheartened, to say the least, because it falls very short of relating the reader to the brutality of the ongoing genocide in Gaza. So these are my initial comments on it.
I just wanted to jump in. Thank you so much for that, Shahd. One of the things that I found striking when I was reading the report is that the commission conducted its work remotely. And that if you take a look at how the commission talks about how it used sources to engage in its investigations. They talk about their methodology. They talk about how they collected open source materials and how they verified these through cross-referencing and used forensic examination and a couple of reputable sources. But to the remoteness, the commission is clear in the report that they conducted remote interviews with victims and witnesses, and that they consulted multiple sources, that they conducted missions to Turkey and Egypt between February and March of 2024 to get a firsthand account. And so that means the individuals that they spoke to, I think they said that they interviewed 70 victims and witnesses, more than 2/3 of them women. But the commission was not able to reach out to those in Gaza. And so it says in the report that their ability to reach out to folks on the ground in Palestine was limited due to the continued fighting, and that Israel also limited their investigations. And that they face significant challenges. So I'm wondering whether those sort of knowledge gaps and sources gaps is reflected in a number of the comments that you just made, because it doesn't seem as if they were actually able to be on the ground and do any investigations.
Just shortly to give the others space, but first of all, it's of course we appreciate the fact that they wouldn't have had access, but that consideration ought to have been taken within their understanding and analysis of evidence. What I mean by that is that should have changed their methodology, but it didn't, and it should have been taken into account that you're actually dealing with a bad faith actor, and meanwhile they actually entertained Israeli narratives of the reality in good faith. So to not adjust your methodology on the premises of this inability to access the brute reality of which you speak is quite, again, disheartening. And then you can see a lot of the referencing goes back and back again to the sources by the Israeli authorities as well as international media, and not to forget that international places like the CNN ran very professional headlines for a very long time, and of course that's something to be spoken of in the future. And it's very sad also that they didn't focus a lot on the role of media here in incitement of violence, and that could have been also an important element to include. But yeah, thank you for bringing that up.
I wanted to just piggyback on something that you just said in terms of the humanizing point, because the role of the media, and particularly to the extent that the Commission of Inquiry relied on journalistic reports for parts of its investigation, it's important to sort of think about how journalism has been conducted. One person has referenced this as, in effect, colonial journalism. Vidya Krishnan mentioned that there is this heavy use of passive voice in reporting, in terms of Palestinians being rendered as statistics, or Palestinians sort of dehydrate to death as clean water runs out, as one headline wrote, but are not actively killed or murdered. And that there is this humanizing way in which names are presented, stories are presented, and people are presented as whole people when we are thinking about the conflict in terms of deaths as it relates to Israelis, which is, of course, any loss of life is tragic. But there is a way in which Palestinians are rendered as sort of faceless hordes of statistics in ways that desensitize and dehumanize Palestinians. And it's interesting to hear you reflect on how you see some of this surfacing in the Commission's report, and actually, unfortunately, so.
Some of the things that you're saying. I mean, I was struck reading the report. Shahd mentioned the number of Israeli references, particularly at the beginning, discussing October 7th and the attacks. It's in the government. They're like .gov.israel reports, websites. But you can cite them, but the extent to which they cited them, there's no references to similar citations for Palestinian sources or governmental sources, although they acknowledge that they did speak to and receive a lot of assistance from the Palestinian side. But more broadly, you can see this affecting other institutions such as the International Criminal Court's work, and the lack of references to Arabic sources or scholars or news sources. And so I think it's a broader problem. It might be, again, that they don't have Arabic speakers, or the members of the Commission don't read Arabic. But I think greater efforts need to be done in order to overcome that problem, because of course it does affect how events are perceived and portrayed. The sources are integral to understanding what happened. So yeah, that's one thing that did strike me very much, as well as beginning the story with the Israeli attacks, or when we come to discuss the issue of arrest warrants, beginning with Hamas. And then the optics, as always, you start with the baddies, and the baddies always tend to be someone from the Palestinian side, and then you bring in the Israelis. So this is kind of, I guess, the way in which things are framed are important. But on the whole, I thought the report wasn't terrible, despite what Shahd has said, and it's still pretty damning reading some of the descriptions of what the Israelis have done.
I wonder if I might get in here. I've heard some of the critiques of the reports, and I approached the reports myself as somebody who'd served on a United Nations Commission of Inquiry, in this case for Yemen. And so I understand the process by which these reports emerge in the world. And they're not written by the commissioners. In the first instance, they're guided by the commissioners. Sometimes they'll be written in portions by the commissioners, but the first drafts are done by people who serve the Commission of Inquiry, who are officials of the United Nations High Commissioner for Human Rights. As part of a secretariat, they include investigative officers, lawyers, gender advisors, military advisors, and so on. And as a result, the process sometimes isn't as directed as it should be. Sometimes you get findings that are broad and diffuse. Sometimes the issues aren't dealt with clearly or clearly enough. For instance, I suspect, and this is a guess and only conjecture on my part, so please don't take anything other than it being that, But I suspect the reason why genocide wasn't dealt with, and incidentally, as soon as I read the reports and found that there was no reference to just genocide or very little, if any, I made my views known to the members of the commission informally. But they did not respond to me on the substance. So this is conjecture on my part. But I suspect they didn't deal with it. It's for a number of reasons. First, the ICJ is seized of the matter. Second, it's such an emotive issue that if they do weigh in on that subject matter, then the critique is going to be, well, on what factual basis can you arrive at that? You've not had any access to the territory, and that's all and good. But there's one more thing that I think might have been controlling, and again, it's just conjecture. The head of the Commission of Inquiry is actually a judge ad hoc in the Gambia and Myanmar matter on genocide, Nabi Pillay. And Judge Pillay may very well have felt, well, if she makes any findings of fact or findings of law that here on a standard that is less than that which would be applied in Gambia and Myanmar, then there may be issues there of confusion in the progressive development of the law in that case. Who knows? That might have been one of the reasons. There may also very well have been differences of opinion by members of the Commission of Inquiry as to whether or not what is happening in the Gaza Strip amounts to genocide. And therefore, in view of a difference of opinion, they may very well have agreed that it's better to remain silent on the matter substantively. There's no way to tell, all this to say. Second, I can't help but share the concern that was articulated so far by Victor and Shahd concerning the humanization of the one side over the other and reliance on sources from the Israeli government. One thing that the Commission of Inquiry did not have, which they do and would now going forward, is a finding by the International Court of Justice that the occupation is itself unlawful, even though the COI, the Commission of Inquiry, had already arrived at that conclusion some months prior. But why does that matter? And it goes to the extremely important point that Shahd has mentioned. And that has to do with the issue of bad faith. From here on in, any claims made by the occupying power, by its governing authorities, by its military, justifying the positions that they're taking with respect to international human rights law obligations, which they are would be bound by, or international humanitarian law obligations and so on, those claims come with an additional burden on the part of the occupying power. They have to prove them. And in the absence of proof, the presumption has to be, by virtue of the fact that the occupying power is physically present in the territory illegally and imposing an illegal apartheid regime or regime of racial segregation on the people of Palestine with the aim of annexing the territory, depopulating it, and so forth. That presumption has to be brought down in how we interpret the law. In this case, there seems to have been a presumption of legitimacy of the evidentiary sources offered up by the Israeli government on what took place on the 7th of October. This is not to say that what happened on the 7th of October is an imagination of people on the left. No, very clearly violations of laws of war and other such took place, crimes against humanity perhaps, on that day. But it just goes to comment on perhaps how the Commission of Inquiry might have been a little bit better in its framing, in its reliance on these sources, and so on, to produce a slightly a different result. There is another side to it, though. One must also appreciate the limits of the Commission of Inquiry. They're there to collect information and collate it and preserve it, but they don't operate on a criminal standard by any means. What you described, Matiange, of their processes, that's standard operating procedure for commissions of inquiry to interview people from abroad, to work outside of the country of reference. Very rarely would they be given access to the country of reference. This is just standard operating procedure. And of course, all they're meant to do in terms of the evidentiary standard is to draw conclusions on the basis of reasonable grounds to believe. And then, of course, it's handed over to the other states to act, or rather states to act, and the United Nations to act. So beware, friends, about just how much we critique. while at the same time being sure to critique where warranted, and there clearly are some places where they are warranted.
Just a short on Ardi. I absolutely agree. At the end of the day, what Israel is doing is so damning that, regardless of what you say about it, it is still going to be a damning report, and it is indeed. And it does, as I said, help us provide a UN source for dispelling a lot of Israel's claims on October 7th and dispelling a lot of their claims in relation to Gaza. So it does serve as a source. And when they were asked, they said that they understand that their own purpose is to feed into the evidence collection at the International Court of Justice, and they felt that this would be the best thing to do. Whether or not we agree with that, but again, at the end of the day, there's a lot to build on and gives us a UN decision. But the thing to affirm is it's still sad that international legal discourse is at a point where this very conservative perception of reality is still the norm, and people would normalize it with each other within a UN belief system. I didn't feel that the Commission of Inquiry really kind of took on board the critique that I was trying to communicate, given that it falls very much far off what they're used to, or how you think when you're, as Ardi said, like within these commissions, the normalization of things. But what I'm saying is what's normalized is quite violent to reality, and hopefully, again, we can reclaim these spaces in the future.
There is a technical point for those who are the very technical lawyers out there that is worth adding, in addition to what has already been said by Shahd and Victor. And we see that with the advisory opinion. I come back to the advisory opinion. Those who've read the opinion will see the very, very clear reliance for findings of fact by the court on the Commission of Inquiry in one of its previous reports concerning the illegality of Israel's occupation. The opinion is replete with references, factual references, and this is actually a unique evolution, if you like, in the practice of the United Nations bodies and the ICJ. It emerged first with the Gambia case and the reference there, or the reliance in the Gambia and Myanmar matter, to findings of fact brought by the fact-finding mission on Myanmar, where the question was for the court whether or not they can actually rely on the findings of fact, and they did in that case, and they've moved very, very far in terms of their practice here in respect of the Commission of Inquiry. So all this to say that despite the concerns such as they are, the Commission of Inquiry's findings matter, and they will be brought to bear in the future, quite possibly before the ICJ. And now that we have a ruling that the Israelis are there unlawfully, they may also be tempered. They may also be tempered by the court in terms of their usage in the future.
Thanks for that, Ardi. I wanted to just add a couple of things. So the Commission reached a number of conclusions, and as I was reading the report, it actually, while not identifying people, it does issue findings about who they regard bear the most responsibility for international crimes, including war crimes and crimes against humanity. And it says generally that senior members of the political and military leadership of Hamas and other Palestinian armed groups and of the Palestinian Joint Operations, as well as senior members of the political and military leadership of the Israeli state, including members of the War Management Cabinet and the Ministerial Committee on National Security, other ministers of the government, and leaders of the ISF. And the Commission notes that it's going to continue its investigations focusing on individual criminal responsibility and command responsibility. So maybe the Commission saw themselves as having the responsibility to look at individual and criminal responsibility. Certainly, they seem to say so explicitly. And I also wanted to note that the Commission, in its report, talks about as one of its findings and conclusions that there is a need to stop the recurring cycles of violence. It calls for strict adherence to international law, It also mentions that there is a need to end the unlawful Israeli occupation of Palestinian territory, discrimination, oppression, and the denial of the right to self-determination of the Palestinian people, and guaranteeing peace and security. So there are a number of significant findings, as you rightfully note, Ardi, but I think that there was still an opportunity for the Commission to do more. And as Shahd mentioned, pertaining to genocide, the Commission talks about Israeli official statements that constituted incitement, that they may constitute other serious international crimes. It highlights a couple of statements that are aimed at systematically dehumanizing Palestinians. And I was struck by the fact that the Commission did not even make findings relating to prevention, or at least preventing incitement to genocide and the like, because during the time that the Commission was investigating, October 7th to December 31st, there were a number of other special rapporteurs and other UN experts who had been calling on the international community to prevent genocide. And so I was struck that the Commission didn't speak to this, but I think that the Commission focused its inquiry on crimes against humanity and war crimes. And I guess we will see whether they issue any other findings.
Yeah. About use of language and why they didn't refer to genocide. And I think the reasons Ardi has given are the correct ones, I'd imagine. I wasn't aware of Navi Pillai's role in... I knew she was on the Gambia-Myanmar case, but it hadn't occurred to me that might be a factor. The ICJ advisory opinion also refers to an old UN fact-finding mission on the Israeli settlements, which I was surprised to see liberally cited in the opinion. And I had the privilege to appear before that commission when I was a legal advisor to the Palestinians in 2012-2013, and I remember that we made the argument back then that Israel's policies and practices were tantamount to apartheid. And there was the commission had 3 members. It was chaired by a French lady. I think there was a Senegalese and a Pakistani deputy commissioners. And I could immediately see in the meeting that the global south, let's say, members of the commission completely were nodding their heads as soon as I referred to the word apartheid, whereas the French chair, was shaking her head vociferously. And in the end, the word apartheid isn't mentioned. Instead, they use the expression total segregation. And I think, again, something similar has happened with the advisory opinion. We're talking about systemic discrimination. There's something about the word apartheid, perhaps also the word genocide, that makes people think twice, or I don't know, makes them not use it when it should be used, perhaps. And so, yeah, when I was listening to what you were saying about the lack of reference to genocide, just made me recall a similar incident with another UN committee of inquiry that was referenced in the advisory opinion.
But if I might just add this to what has been said, the uniqueness of this Commission of Inquiry is that it is a standing Commission of Inquiry. It will not end until such time as Israel's physical presence in the occupied Palestinian territory ends, and perhaps even beyond that, because the scope of its mandate goes well beyond the occupation. So the point is that they can do a better job of what they do. Matiange, the point you raised earlier about incitement, spot on. I totally agree with you. And so these critiques are important. They're important to let the Commission know that they can do their job better, and we'll see how things emerge in the future in their next reports.
Thanks to everyone for that overview of the Commission of Inquiry. Another of the relevant international institutions that are addressing the situation is the International Criminal Court. And in May, the ICC prosecutor Karim Khan requested an authorization to seek arrest warrants for senior Israeli and Hamas officials, arguing that there were both a parallel international armed conflict between the state of Palestine and Israel and a non-international armed conflict between Hamas and Israel. The pretrial chamber has not ruled on the prosecutor's request. It's still pending. But Victor, what do you make of the prosecutor's request? What do you see as kind of the most interesting points there, or noteworthy points there?
Thanks, Paris. I thought it was a very bold and courageous decision, despite the optics, going after the Hamas leaders first and then the Israeli leaders. Because when you look in detail at at the crimes that they're accused of, you can see that the crimes leveled at Hamas, 5 of the 8 crimes are all related to the hostage situation in captivity, so they're actually quite limited, whereas of the 7 crimes leveled at Israeli leaders, they're much broader, they're all continuing, and they include crimes against humanity. And I also think that it's I mean, let's face it, the Hamas leaders mentioned are not people who travel to Western airports and go to international conferences. They're underground. They're used to avoiding states where Hamas is on various terrorism lists. The Israeli leaders, on the other hand, are fettered in the West, and it's going to be much more challenging for them now, assuming these warrants are issued. If they are issued, it's much more challenging for them to do business as usual. And we saw this as the conservative government, the previous conservative government in this country was horrified at this prospect, and it's quite interesting to see now that we have a change of government, a government that has just changed its policy towards the ICC. So there was to go a bit further, Paras, the last government tried to slow things down by raising an objection on the grounds that the Palestinians don't have criminal jurisdiction or enforcement jurisdiction over Israelis in the West Bank due to the Oslo Accords. But that now, as I understand from press reports, has been withdrawn, which is good news. And so we wait to see what happens with the pre-trial chamber, whether they issue a warrant. And if they do, I think, again, that's just another, in addition to the advisory opinion, the commission of inquiry, the case South Africa's brought against the ICJ, this is another potentially big moment that could really restrict the capacity of senior Israeli officials to do business as usual with senior Western governments who are also their biggest arms. Well, I know the United States is not a member of the court, but still, European states are. Italy, Germany, and the UK still provide the Israelis with important military technology and intelligence and other support, and this will make it more difficult to continue that.
Thanks for that, Victor. So just wanted to clarify, since we have so many people situated in many different places, that you were talking about the United Kingdom with respect to its change in policy, given the new government that has come in place. But I wanted to back up a little bit just because the current application for an arrest warrant is responsive to October 7th and the atrocities committed then and subsequently. However, Palestinian representatives have repeatedly sought to get the ICC to invoke its jurisdiction over crimes taking place in the territory, dating back to 2009 and 2015. Palestine was formally recognized and allowed to become a state party to the Rome Statute in 2018. And at that time, it submitted a referral to the prosecutor to investigate in accordance with the jurisdiction of the court, past, ongoing, and future crimes within the court's jurisdiction committed in all parts of the territory of the state of Palestine. And the ICC opened an investigation in 2021 to cover alleged crimes committed in the occupied Palestinian territory dating back to 13th June 2014. And so the court has jurisdiction dating back to 2014. Thus far, the application for arrest warrants concerns the events and alleged crimes that took place on October 7th and thereafter. And so one of the things that I know has been a subject of concern regarding the application for arrest warrants is both the scope of the arrest warrants in terms of the temporal scope, but also sort of substantively what is covered and what is not covered, I guess, with respect to the arrest warrants. So I don't know if anyone wants to offer any thoughts on this, but I think it's worth us spending some time thinking about.
I can jump in quickly just to say that the prosecutor, Karim Khan, has said that this is just the first stage, that this isn't the end, and that he's also looking at crimes in the West Bank, which I assume would include the settlements and possibly the apartheid has been raised. So it's possible in the future that they will look at those crimes, but those crimes are perhaps another reason why the ICJ didn't look at it. They're a bit more complex, a bit like genocide. You need a bit more work. But I don't think they've ruled it out. but they just responded to the latest conflict because they had to, in a way. But it remains to be seen what they will do going forward. But I know that the court is has set up a team, as you've seen in the news, and they are working on these issues. So again, I expect to see. It's just a question of time.
That's actually a welcome note from Victor. One of the things that jumped out at me following the moves by the Office of the Prosecutor to seek approval of the issuance of arrest warrants was that it's just focused on Gaza and conduct of hostilities. But taking a step back, I think what Victor says is spot on. Certainly, we have to take at face value what the Office of the Prosecutor says, that this is just the beginning, as Victor says. The obvious low-hanging fruit for me was settlements. In fact, that's why the Palestinians acceded to the statute years ago. And there, what strikes me as odd, but which I hold out hope for, is that you don't have an evidentiary problem with the establishment of settlements, neither do you have any defense for the establishment of the settlements. That it isn't quite literally, and there are very few cases like this in law. It is an open and shut case. Decades worth of Israeli state policy led by the highest echelons of the government and successive governments since 1967 at every walk, in every area of government, whether civil, political, military, and so on, economic, they're all very clear. They intend and are committed to settling the territory, and all of that in violation of the Fourth Geneva Convention, Article 49, Paragraph 6, and of course the Rome Statute. So at some stage, when they make a move, it won't be very difficult for them to establish individual criminal responsibility for those actions. Most particularly, and you see this is a point about how all of these processes sort of build on one another, most particularly following the advisory opinion, which we spoke about earlier, because the court has made it very clear not only are settlements unlawful, but that the regime, the settlements, all of them have to be brought to an end unconditionally and as rapidly as possible, removed from the territory. That will make it easier for the court, for the prosecutor to move on charges of war crimes for transfer of civilian population to the territory it occupies by the occupying power.
Shahd, I saw that you wanted to weigh in here.
So my perspective is a bit more critical of this because to me, I don't know how, like if I was an international criminal lawyer, I would be currently facing an existential crisis because it would be very sad if this is the standard that we would hold international justice to be at, in the sense that they've played hot potato for this for almost 10 years now and not managed to reach something. And of course, Palestine, the case of Palestine is one of the most well-documented cases. Palestinians have learned the lesson hard and worked as much as possible to document. So the fact that it was pushed so far, and the fact that even now with the arrest warrants, it feels like Don Quixote's battle with windmills, and it feels like the court is actually entertaining logics where Israel and economically advanced states are buying themselves time and also buying themselves very reductive technical comprehensions of international criminal law. Like at the moment, the Palestinian civil society, in the middle of handling a genocide, has been pushed, tens of us, to handle a ridiculous amicus curiae participation in the court's proceedings because of the UK's intervention in relation to very technical questions that really blur the bigger picture. What the UK is doing is buying Israel time, and we're looking at babies who are losing their heads like every day. Like this has not become just something that like every single day that's footage that's coming to our screens, and the fact is you have privilege and capacity to speak in the name of international justice in a way to affect the political discourse. Meanwhile, you allow yourself to stand next to the political status quo. And at some point, if you actually stretch enough time, to it, there becomes a very big question of whether or not you yourself are a part of the problem in legitimating the ongoing violence. And this is a critique that I've heard often whenever I speak to Palestinians and other people in the region about international law. And they ask me about my own responsibility of whether or not I'm selling them a phantom that will never reach them. And I hear their critique very well. Karim Khan to me is not someone who is competent to take office, and this is just clear. He lacks the impartiality required. He lacks the insight required, and also lacks a moral compass as a human being. Anyone who should be partaking in such a high office ought to have a very clear moral standards as a person in order to partake in their duty in a way that befits the very big words underlying such a discourse of international criminal law. For us to be waiting, and not only that, as you kindly noted, not like the way the arrest warrants are framed. Again, this is a development. At the end of the day, of course, we have reached a point where we're able to talk about Netanyahu. But the question is, does this only serve a possible also change in status quo policy, where we're just saying that this is just individuals and not a systematic policy of a state? And rather than taking the more complex, very obvious reality, what the International Criminal Court is actually partaking in is the distortion of reality. So yes, and I would engage with these processes, and I'm wasting my time in engaging with these processes, but also with a very clear understanding that what I am dealing with is fictional bureaucracy that is made to sustain a hypocrisy of liberalism in a way that really it's just fascinating for me to hear that students in Gaza were still learning about international criminal law through Telegram by one of their professors who was just recording the classes on a voice message. Because if you are currently, and you can see, of course, the stamina of us having going through the effort of engaging with this framework, but then this framework institutionally being designed in a way to make this so far-fetched. But we are, again, developing, and again, it's Israel that has shot itself in the foot by its own extravagant violations of international law, where there's no way to defend itself. But I wouldn't hold my breath that this is where I would find any glimpses of hope. And actually, I would be much more inclined to say that, to declare the death of the discipline in light of, again, a live streamed horror film that just is beyond what we could have imagined seeing in our lifetimes.
Shahd, your comments spark and provoke a number of things. So thank you for your offerings. But one of the things that I'm thinking about is the way in which the ICC's investigations, in terms of sort of additional procedures, have been added or seem to have been added to the situation compared to other situations, which has furthered a sense of sort of selectiveness in terms of accountability or double standards, or just that there's a way in which the situation is proceeding differently. Some have talked about under-resourcing, understaffing of the situation prior to investigation in 2021, opening of investigations in 2021. But there's also the creation of this expert panel that the prosecutor used to weigh in, expert panel of international lawyers to review evidence and to engage in the legal analysis in the application for the arrest warrants. And you also referenced the amicus procedure that the United Kingdom initiated, but has since withdrawn from, as sort of procedural hurdles to investigating with the situation in earnest. And I don't know if anyone else has thoughts about sort of how procedure is being deployed in this situation in ways that might drag the process on, or is the procedure being added sort of as a, to protect the ICC in terms of charges that might be leveled against it for weighing in here.
I'm happy to have a response to that. Look, I think it's both. There's no. I think one of the things that we need to do when we look at all of these processes, whether it's the ICC or the ICJ and so on, I always often tell my students this, is to disabuse ourselves. And I'm not suggesting that anybody here is under this position, but just in general terms, disabuse ourselves of the notion that any one of these processes is going to liberate people, certainly not the Palestinian people. No, they're all part of something else. Law can sometimes, if properly enacted, developed, applied, enforced, can help bring some modicum of justice. But on the big structural issues of inequity and deprivation and so on, fascism and so on, law is going to be limited in any case. That is the prism through which I view what's happening at the ICC. Take, for instance, the following as a thought experiment. Let us suppose there were no procedural hurdles to cross. Let us suppose the office of the prosecutor moved 10 years ago, as rightly pointed out by Shahd. He should have done, and she should have done before him, right? Let us suppose that all of that process produces a finding that the sitting Prime Minister of Israel and his or her cabinet, or his cabinet, at the time, is responsible for the commission of a series of internationally wrongful criminal acts under the Rome Statute, and arrest warrants are issued, and people can no longer travel. Does any of that end what the Palestinian people are fundamentally facing on the ground in a settler colonial society? Absolutely not. And so this thought experiment, I should hope, points up the limits of international criminal justice, international criminal law, and so on. The same holds true with all the other things we've been talking about, to varying degrees, the advisory opinion and so on. So I tend to look at these things from a more pragmatic standpoint. I expect politics to play in the process at the International Criminal Court. And those politics produced, to answer your question, Matiange, those politics produced a decision on the part of Karim Khan to set up this body of special advisors for fear that had he not, it would have been his neck on the line with the other powers that be. Anybody who's been engaged in the Israel-Palestine conflict or press for justice for the Palestinian people and the ICC and its process for the past 20 years would know and would have appreciated that every time you mention Palestine and the ICC, there would be some blowback on you to say, well, not now. Now's not the time to move on that. The threat of moving on that, the threat that would pose for the life of the court, for the life of the project would be too great. All of this implies that there's a politics. It's a direct acknowledgement that there's a politics to how Israel-Palestine plays out for international criminal law. So I take very seriously and agree with Shahd's large critique. At the same time, it is what it is, friends. Those political factors, not going to change. It's a marked feature of the field. So in a sense, you have to work with them, difficult though it may be, and accept that, of course, the prosecutor is going to set up, for instance, this special body of advisors to protect him. Of course, Fatou Bensouda is going to ask what I thought was an absurd question of the pretrial chamber on the territorial scope of the jurisdiction of the court. Of course, it's the occupied Palestinian territory. Anybody who knows anything about that conflict would have been able to answer that in quite literally 30 seconds. And that was a delay of some length. You're seeing the same delay being brought to bear now with the United Kingdom. And despite the fact that the new government has withdrawn their objection, if you like, on jurisdiction, that has opened up this Pandora's box, or this box of action for other states to do, as Shahd rightly points out, delay justice. And that's what's happening. But make no mistake about it, friends. That's what the international criminal law process is going to produce in any case. The question is, how well do you manage that process? That's what I have to say.
I agree completely with what Ardi has just said, but I'd also like to add that we shouldn't forget that it shouldn't affect their work, of course, but they're human beings. These prosecutors, and it's come out in press reports, the previous prosecutor were subject to all kinds of direct threats, intimidation, phone hacking, threats against their family, their children, their husbands. They were threatened with travel bans. The court was threatened itself with sanctions from the United States. So it's a different ball game going after the Israelis and sadly going after other countries. We know that, and that I think also explains the optics. Having this special panel of prominent barristers, nearly all Brits, actually, they're all Brits, on this commission and kind of framing it as going after Hamas first. But the reality is there is change. It's small, it's subtle, it will take time. It's not what we want. It's taken too long, but it's happening, and it's happening in all different places. And I think that's something, if we can have any optimism, and it's very difficult to have optimism on this subject, there is some room for optimism that hasn't been there before.
Just quickly to note what Victor has just noted, the experts that were hired by Khan, again, primarily British people, but also a lot of them with military backgrounds. And when you think about the type of expertise needed to navigate such a context, I hardly believe that that's the most suitable expertise you need. Yeah, you don't need agents of empire to judge on the crimes of empire. But again, I believe that still, and perhaps here you have the plurality of voices, that it's important to keep also these institutions with a sober reminder that they don't have a monopoly on the language of international justice, and nor is this our monopoly on the conceptualization of justice, conceptualization of reality. And it's very important to sometimes also remind them of the absurdity of the acts that they are partaking in. And sadly, as Ardi said, the court has said that we will have to go on with the amicus briefs and with the very technical discussion on jurisdiction. The important point to note is that the ICJ decision is going to support us because of its ramifications with relation to Oslo. But yeah, still, when you think about the human toll of it, it is taking a long breath by also indirectly traumatized army of Palestinian and Arab and other ally lawyers who've been working tirelessly for 10 months. So again, like from the position of where we stand, for us to take further absurdity is also a form of torturing us, even if it's just psychological, and even if it's very indirect and nothing in comparison, of the reality, because we really conceptualize the reality of which we talk and are really struggling to translate it across these institutions that were not built for us. And the language of justice has to also be forefront with the language of politics. And sadly, international law has taken the forefront of that discussion. And here is what me trying to also promote alternative forms of thinking by also inserting that critique within these institutions. They need to sober up, and someone needs to tell them not to take themselves too seriously, because a lot of it is ridiculous, really.
So just to put a fine point on the discussion here, I think that the Palestinian situation before the ICC is situated in a long host of crises that the ICC has faced in terms of its credibility. The Afghanistan situation is one. And what I hear from this conversation is both the role that power and politics is playing in this particular situation. And we will see what the court does with all of these different amici that are before it in terms of making determinations about arrest warrants. But I think one of the things that has come out in particular in the US's response to this, which is a bipartisan response, which has been to challenge the integrity of the court. When Karim Khan came to the U.S., one member of Congress said, the court is for thugs like Putin and thugs in Africa, not for others. And so there is a way in which the court's actions here is challenging charges of selectivity but it's also being confronted with powerful actors who want to limit the court's reach. And so we will see how things develop. But I think Shahad rightfully points out what happens at the ICC in some ways is immaterial given the devastation that is happening on the ground. And so to end, I think we should just think about moving forward, and given our discussions thus far, what do you see as the biggest source of hope? We've spent a lot of time thinking about the different challenges for realizing and implementing decisions across several mechanisms: the International Court of Justice, the Commission of Inquiry, the International Criminal Court. Might we end by thinking about what do you see as the biggest source of hope or opportunity in terms of thinking about realizing substantive changes on the ground?
I guess the biggest source of hope, I think, is global public opinion, to the extent that we can ascertain what that is. I mean, I was speaking to my wife the other day, and I was saying, when I was a student during the Second Palestinian Intifada, there were like maybe 4 people on campus campaigning about, criticizing what Israel was doing. Mostly it was Islamic societies and others who were the most active. And now, we've got these huge numbers of students at my university, other universities. You've seen it in the United States. You've seen it on social media. You've seen it in the votes. In the votes in various countries, in the elections here, where people either lost their seats or won their seats, depending on their views on this conflict. So I think there has been a change, especially when you think about what the situation was on the 6th of October, where it looked like this conflict was, from the Palestinian perspective, over. The Saudis were supposedly going to recognize Israel, and they'd be completely abandoned. And Netanyahu was like walking around like some kind of peacemaker. Now he's seen as a global war criminal. And Israel's still fighting this conflict in the Gaza Strip. Declared mission accomplished several months ago, which hasn't worked out. There's conflict on the north. There's these multiple actions at various international courts. So it's none of it's good news. But I think what we're seeing is all these small steps are contributing like a cascading effect to, I think, a shift in opinion, and people are now able to discuss things they were not able to do, to talk. Even the language and the discourse, the arguments made before the ICJ in the advisory opinion were so much more radical than were made 20 years ago. You couldn't imagine that these arguments could even be made. I remember the word Nakba, for example, was hardly anyone knew what that meant 10, 15 years ago. Now it's almost common discourse. People know exactly what you're talking about, and they're aware of the history and the injustices. And I think that's a big change for the better.
Thanks so much, Victor, for weighing in on that. So thinking again about sources of opportunity, places where you are finding hope in this current moment. Let me turn to Shahad.
In short, I think that the suffering that we have seen in the past 10 months can only be redeemed through the initiation of a moment where Palestinian rights are taken in their full. And what I mean by that is the redemption of the Palestinian people for what happened in the past 75 years through realizing fully their own rights and everything that has happened. That can only be that accountability, hearing the affected population, validating their experiences, humanizing them, and looking at a people whose culture has become inevitably one of resilience and resistance. That's the only way to redeem the people, and I don't think that there is any other option for any of us. The only source that I have of hope is the will of the people and their realization, as well as their understanding of the pain that has been struck on the consciousness of humanity in the past 10 months plus 75 years. I'm not exceptionalizing the Palestinian discourse as much as I'm saying that it is inevitably, of course, a symptom of a larger ailment of this world. But if we aren't as a humanity capable of realizing this. And I think time as well is a source of hope, because I believe that with time comes truth, and the truth here is just too dire for anyone to disagree with. Hopefully, towards the future, our will remain strong in order to speak truth to power and to ensure that the people of Palestine get the accountability that they deserve, and they no longer remain in a position of ethical loneliness. Because otherwise, I don't know what these 2 million people are going to do. Now, 2 million minus what is most likely estimated to be over 100,000. And if I myself had lived through such times, the trauma that I have will only be healed by a promise or a hope of liberation and of the end of this, and of the fact that if I have children, they wouldn't have to live through what me, my grandparents, my great grandparents have lived through. So that's my these are my sources of hope and my concluding thoughts.
Well, however does one follow that? I actually associate myself with both what Shahd and Victor have said. My hope derives from being human, and at the bottom of what makes us humans is the belief. I should hope that that life is worth living, and that in the end, justice will prevail. It sounds cliche, but it's true. The Palestinian people have been through a tremendous toil. Theirs is a just cause. Ours is a just cause. They know it, and so too does the other side, if you like. And I believe that I draw hope from the fact that these people just press on despite it all. Law is one way we do it, but it is it's a relatively small aspect of how we do it. And the fate of the Palestinian people is to have to marshal whatever resources they can, whatever resources are at their disposal, to keep the moral high ground and keep pressing on. And that's what they're going to do. More technically, more practically speaking, and perhaps because I've been working on the case for such a long time, I think the advisory opinion, as I said earlier, signals a sea change and forms the basis of a great deal of action that can be taken on the international plane to press for Palestinian rights. And I invite the international community to do that, and for men and women and people of conscience to read the opinion and figure out ways how they can give it effect, even in their local communities. There is an illegal presence in occupied Palestine. It is Israel's presence. It is an apartheid and racial segregationist regime. And now it is committing the most heinous acts known to man against the Palestinian people. It is only a matter of time before that ends. The question is when.
My goodness. What to even say after following the three of you. I mean, I think we've spent some time in this podcast looking at the recent pronouncements of a number of different international bodies on Palestine to see what they surface about what they've chosen to condemn as violations of community norms. And I think from all of your comments, one of the takeaways that I'm getting is that, the expressive power in naming a given situation of mass atrocity, be it war crimes or genocide or crimes against humanity or the occupation and so forth, has social meaning and effect that is independent from legal connotations, right? And so power has often resolved the question about who is entitled to sort of define and invoke these charges legally, socially, and practically, but thinking about what we choose to condemn and how we sort of sociologically can change beliefs about what should and should not be condemned, and how we think about revalidating any sense of social solidarity in this moment. And so I think if I have to reflect on what has given me the most sense of hope and opportunity is thinking about the solidarities that have been formed, and not only now, but that have been formed for years. And I think that our actions in this moment and inactions and what we are naming and not naming international law included in that, international institutions included in that, states, civil society actors, and the like, tells us so much. And so what I am most optimistic about is the solidarities that have been formed across different spaces and places, geopolitical spaces, and thinking about how the challenge to defining, who and what matters, who is or is not disposable, who deserves empathy and recognition, and who does not, has been sort of forcefully met. And in a number of ways, I think the Palestinian situation is freeing us all. And so I am finding hope in our ability to continue to think about the role that power plays, and to question the role of power and its moral authority to name and shape collective memory through law and beyond. So thank you all so much for all of your offerings and thoughts today. It's really been a really generative conversation. I thank you so much for your time.
Yeah, thank you so much to each of you, Shahd, Matiange, Ardi, Victor. We really appreciate your time and all of your thoughtful, important reflections. We'll be covering all of this at Just Security. Thank you again for joining the show.
Thanks a lot.
Thanks so much for having us.
Thank you. It's really been incredibly moving being in conversation with you all. Thank you for your time.
Thank you very much. It's been a pleasure to be here.
This episode was co-hosted and produced by me, Paras Shah, and Matiange Sirleaf, with help from Audrey Belliette and Clara Abt. Special thanks to Shahd Hammouri, Ardi Imseis, and Victor Kattan. You can read all of Just Security's coverage of the International Court of Justice, the International Criminal Court, and Israel and Palestine on our website. If you enjoyed this episode, please give us a 5-star rating on Apple Podcasts or wherever you listen.